Commissioners, good evening. This is February 10, 2020 for the commission meeting. As your commission is aware, there's the chair and the vice chair are not present, and therefore, in order to select a presiding officer for this evening, we'll need to have a motion, a second, and a vote. So the floor is open for such a motion. Mr. Beckett.
I nominate Philip to be the chair tonight.
Okay, it's moved. Is there a second? Okay, Mr. Fisher seconds. Is there discussion on the motion? The motion? Go ahead and call the roll.
Okay, Beckett?
Yes.
Fisher?
Yes.
Semler?
Yes.
Stewart?
Sure.
Whitman?
Yes.
All right, Mr. Stewart, proceed.
So I don't have to move.
No.
All right. I would like to call the Plan Commission meeting to order. Today's Monday, February 10th, 2020. Jean, could you please call the roll?
Beckett?
Here.
Fisher?
Here.
Semler?
Here.
Stewart?
Here.
Whitman?
Here. All right, so the first item on the agenda is the council update. And do you have an update?
I do. Good evening, Commissioners. Thanks for allowing me a few minutes to present to you. I might have mentioned to Iris that I'm not able to make it to twice a month, and so I'm able to commit to one meeting a month. So you'll find that I'll probably try to consolidate a few council meetings into one, so if that's okay with you. But as needs arise, and if there's a need for more frequent council updates, I'm more than happy to do so. So just feel free to reach out and let me know. Since we last met, there's been a couple of meetings, and I'll have to be honest, the meetings have been rather short in agenda. So I think that the last meeting that we had on February 4th, I think broke all records. It was 42 minutes in total. So a brief agenda. So I'll start there and I'll work backwards. And so on the February 4th council meeting, we had instructed staff to go ahead and prepare an ordinance with regards to the plastic carry-out bag ban that's been implemented by the state of Oregon. So we, as a council, decided that we would follow that ordinance, but with the exception that we're going to change it to 10 cents instead of 5 cents, with the understanding that we believe that a 10 cent would affect behavior more than a 5 cent charge would be. So everything else is the same as the state statute, and so we went ahead and approved that ordinance. And we also approved our 2020 council policy and goals, and that was a result of the retreat that we had earlier in January. And so we had a chance to spend pretty much most of a day together to talk about what we'd like to see as goals and initiatives for the council. That was also under the direction of our new city manager, Martha Bennett. So she had a very, I believe, a very effective approach to getting all of us to speak and be able to actually come to agreement on some common goals and initiatives. So that was approved and for 2020. Prior to that, that was our January 21st meeting, and that one, the highlights of that one really was there was the state's can't remember what bill it was, but it essentially allows the cities to be able to change their speed limits to 20 miles per hour in residential areas. And so we instructed staff to come back to us with some research and consider potential areas we may implement that. We haven't made a commitment whether we haven't made any decision. We just want to know which streets may be affected by that potential new rule that could allow us to be able to lower the speed limit. There were some counselors that had said, hey, make my street a 20 mile per hour limit. So, but those are things that I think we're going to be coming back later in the spring to be discussing. And as I hear more from that, that'll definitely be something I'll bring to Plan Commission to present. We also discussed the Tryon Creek wastewater treatment plant. that project. At this point, staff had asked for an additional $450,000 to continue the RFP process in order basically to figure out, shall we upgrade the existing plant or shall we replace it altogether? And I saw a few eyebrows raised as well too, and mine was one of them. But to get to that point, staff recommended we spend another $450,000 to do that. Council decided to move forward and allow that request. And so we should hear back in the springtime about the results of that. That is quite a big project, and it's something that I think that we have clean water, and now we got to address our wastewater issues, and that's something that we are. We have a partnership with the City of Portland. Currently, as you might know, the wastewater treatment plant is owned by the City of Portland, and it needs some upgrades to be able to comply with the new EPA standards. So, the EPA standards, yeah. And really, those were the main highlights. As I said, the past couple of meetings have been very brief. So, and that's what I have to present. If there's any questions, I'd be happy to take them. Commissioner Beckett?
You mentioned the Tryon Creek wastewater treatment.
Mm-hmm.
The city is in the midst of reading a book called Rising, in which there are predictions of 3 to 6 feet of rising tide within the Willamette River.
Mm-hmm.
The Tryon Creek facility or the whole park down there would be largely flooded. Has that been taken into account with the wastewater treatment plant?
I couldn't speak to that directly, but I know that if that area floods, we probably have a lot of other problems beyond just the wastewater treatment plant. I think it would be affecting an entire region, not just our city. So that's one of the things that one of the proposals is if we were to replace the plant, even coming to a smaller footprint would not resolve that issue about flooding, because it would be essentially in the same area, but just on a smaller footprint. So, yeah.
Lifetime of a treatment plant should be more than 20 years.
Yeah, they're looking at
That kind of rise might be expected. Who can say for sure?
Yeah, I think we're looking at it's a 50-year decision, so, yeah. Any other questions?
Thank you for the update.
Yeah, our pleasure.
Got it. Nope, nobody's heard me so far, probably. All right, moving on to item 5 on the agenda, the Commission for Citizen Involvement. General updates. Mr. Siegel, do we have anything for that item?
I don't believe we do, Chair. Thank you.
All right, that being said, moving on to item 6, findings, conclusions, and order for the Luscher Farm concept plan. Last week, there was a public hearing. This week, we have the findings to vote on. Now, do we ask for comments from the commissioner, or do we just call a motion for this?
Yeah, so Acting Chair Stewart, these findings are intended to reflect the Commission's tentative recommendation of approval on the concept plan, and all commissioners are eligible to vote on the findings, even if you had not attended the hearing. I understand that some of you may have, or Commissioner Stewart may have reviewed the meeting and you're able to vote on it. I would just say that the commission had recommended approval. The testimony that you received was, there was testimony in favor of the concept plan supporting testimony that was opposed to some elements of what those who were testifying thought was part of the concept plan, and the response from staff, I think, clarified some of the issues that were raised there, that the questions about off-road bicycles or skills courses and development of athletic fields at Luscher Farm, that this is a concept plan, so it's not binding, and future development of recreational facilities on the property would still, wouldn't be permitted until the city amends its comprehensive plan. The properties are annexed into the city. Of course, Metro has to amend the urban growth boundary before any of that can happen. So what we've attempted to do with the findings is just respond to provide the context for some of those questions and comments that came up in the hearing, and the staff is recommending approval.
Okay, so
So
I guess if there are no further comments, I will entertain a motion. Just as we're going forward in this meeting, though, since I can't see the little screen there, if you guys have any comments, just kind of either raise your hand or just start talking, and I think that's going to be probably the easiest way to do this. Is there a motion?
I make a motion to accept the findings, conclusions, and order PP 19-0012.
I second it.
Any discussion? I, like Mr. Siegel was saying, I think I'm the only one that wasn't here last week that's sitting up here tonight. I did have a chance to review the video from the hearing, and I think the only comment that I will sort of echo, I think one of the commissioners made, was the idea of providing future services. I think as the area is improved over time, there was talk about educational programs and things like that being introduced to portions of the properties. And I think the fact that you've got some historic structures on site there, having fire hydrant service there in the future, I think is pretty important. But other than that, I think I've seen enough in the video to be able to vote. So all those in favor, please say aye. Oh, I'm sorry. Yes. Yes, we can. Please go ahead.
Okay, I read through the plan again in preparation for this meeting, and I've had a lot of involvement with Luscher Farm over the years. It's a tremendous facility. It's got so much community involvement. The preparation that went into preparing this has gone on for 20 years. The record is that they've had input from over 1,800 people in preparing the detail that goes into this. We've got everything from the sports field that already are on the west side of the plan to the community gardens of people that have been putting crops in there and having plots for decades. The clematis garden is ranked as perhaps the most diverse variety of clematis in the entire North American continent, and the biggest such garden west of the Mississippi. It is really an amazing thing. If you haven't gone to see it yet, you owe yourself this treat during the spring and summer months. Not to speak of community involvement in so many other ways with the building there and the involvement of community members in the farmhouse. And the only fear that I've heard expressed is once this is under this, it's already owned by the city, but that once it is under the urban growth boundary, it'll come out from under management by Clackamas County. That in itself frees up certain restrictions. I don't claim to understand quite what those restrictions are, and maybe there's an expert here that can explain that. For instance, there's apparently a distinction between commercial agriculture that's allowed under the county management versus urban agriculture that would then be included once it's in the urban growth boundary. And I don't quite understand the distinction there. So someone might want to explain that. But by and large, there's a lot of complicated detail in the documents that we've been presented with, almost all of which are very favorable and very good, most of which will not change just because it comes inside the urban growth boundary. And I'm very much in favor of our moving ahead with this proposal.
Any other comments? Thank you. All right, I think we're ready to vote on the findings. All those in favor, say aye.
Aye.
Aye. Any opposed? All right, motion carries. Thank you. Moving on to item 7 on the agenda is a public hearing for the Community Development Code amendments related to the R6 zone structure and design standards. Now, I remember in the past, I used to read this statement. Do I need to do that?
Well, Mr.
for
Chair, I'll
public
be happy to read it.
Okay.
And get it started here. This is a request, this is LU 19038. This is a request from the City of Lake Oswego for amendments to 2 figures illustrating the R6 zone requirements for Chapter 50.06.001 of the Lake Oswego Code. These amendments are identified by staff and the First Edition Neighbors Forest Hills Neighborhood Association through the use and application of the code. Staff coordinator is Ellen Davis, Associate Planner. This is a legislative decision, which is generally a policy decision within the discretion of City Council. The Planning Commission will review the legislative proposal and make a recommendation to the City Council. Although a legislative decision may be discretionary, it must also comply with any applicable state law as well as any applicable statewide planning goal or administrative rule adopted pursuant to ORS Chapter 197. An amendment to the Lake Oswego, amendment to the Community Development Code must also comply with the applicable provisions of the Lake Oswego Comprehensive Plan. The public hearing process will be a presentation by staff, then testimony will be received from the public. Individuals will be allowed up to 5 minutes. Recognized neighborhood associations, homeowner associations, government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. The time limits do not include time taken by questions from the commission or responses to those questions. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. Any person in attendance may cede his or her time for testimony to another person, but in no case shall any person's testimony be increased to greater than 10 minutes. So at this point, I would ask the commission members, starting with Mr. Whitman, to please declare any financial conflicts of interest. None?
No, sir.
None? Mr. Beckett? None? None?
Done.
All right, with that, Ellen Davis with the staff report.
Good evening, commissioners. So tonight might look a little bit like a meeting we had on December 9th because the graphics have not changed, so it's not deja vu. It really does look that similar to the Planning Commission work session that we did before. Before I forget, we did receive one comment by Carol Ockard representing the First Edition neighborhood, and that was in favor of the proposed amendments. That's the only written comment we've received. So the first code graphic that we would like to replace is this one. So this is showing identification of primary and secondary roof forms. The reason we care about primary versus secondary roof forms in the R6 zone, just in First Edition, is because they have a requirement that primary roof forms have to have at least a 612 pitch. It can be a steeper slope, but it needs to be at least 612. Whereas the text of the code, which we are not changing, says that secondary roof forms do not have to meet that minimum roof pitch. So you can do whatever you want on your secondary roof forms. And the text says secondary roof forms, parenthetically, such as dormers and porches, but this graphic doesn't really reflect that. And also, after meeting with the First Edition Neighborhood Association, they intended primary roof form to be more than just one single roof form. So we wanted a code graphic that could better represent the intent of the text. We don't want to change the text, change the regulations, just make it clearer for people who are trying to interpret our code. So this is the code graphic that we are proposing. You can see we've got a little bit more complicated of a house going on, which is more similar to the shape and scale of homes that we do see going up in first edition. And we've called out that there are multiple primary roof forms. Roof forms over any major habitable space are considered primary and would need to meet a 612 pitch. The dormer and the porch are secondary and would not have to meet that. So we're trying to just make this clearer and more user-friendly, and also matching some of the neighborhood association's concerns about the graphic before had kind of a wide house, and they were concerned that it didn't look like a house that would be likely to be built in first edition because we do have narrower lots in the first edition neighborhood association. So we've scaled the house, made it less wide, made it narrower so it could fit on a realistic lot in the first edition neighborhood. And there was a question at the work session to ensure that the roof pitches shown are 612, and they are indeed 612. So we are accurately reflecting that as well. And then our next code graphic, this is an existing code graphic. We're looking at, this says front porch and garage measurements. One issue with this old code graphic is that the upper left-hand corner lot has actually two discrepancies with the text of the code. So the porch that is required along the front of a house in first edition is not allowed on the side, the avenue side. It is required to be on the front narrow portion of the house. So that porch is incorrectly shown in the upper left corner there. And then also the garage that is shown there has to be 2 feet back, or at least 2 feet back from habitable space and not a porch. So it's got some discrepancies going on with that code graphic currently. It also devotes a lot of, or it gives a lot of space to an unimproved alley, which the first edition neighbors were the ones who came to me and said that we don't have a lot of unimproved alleys here anymore. We don't think that we want to show this in the graphic. And I looked through our LO mapping system, our interactive maps, and I agree with the first edition neighbors that I could only find 2 properties that have a completely unimproved alley in first edition. And we are not getting rid of the text that would address those properties that have an unimproved alley, but it just isn't worth devoting a third of the graphic to a situation that no longer exists for the most part. Another issue that the neighborhood association brought up is this size and the width of these lots. These do not look like typical lots in the first edition neighborhood, which again are more narrow. So our proposal is to have a new garage location diagram to replace that old one. We're trying to match the development that you see in first edition better. So we've changed the lot sizes to match the width and length of current properties in first edition. We've shown the public right-of-way and improved alley in a slightly more gray color to show that there is often quite a bit of public right-of-way in front of and around these properties that is not part of the property in first edition. They have very wide rights-of-way. And we've also corrected our errors in the past to make sure that our porches are in the right place and that our garages are meeting all of their setback requirements. So this is just to comply with our code. There was a question during the work session to ensure that all of the setbacks were correctly shown on this diagram, and they are. They have been measured to scale and do match the descriptions given in the graphic. So we have double-checked that, and everything is still okay. So that was it. If you have any questions, I'd be happy to help.
Does anyone have any questions of staff? So I guess we're at a point now where we would normally take public testimony, but I neither have blue cards nor anyone looking like they're wanting to testify. So I guess we will close the public hearing and move into commission's deliberation. Once again, if you have a comment, just.
I don't think there's much to debate here. We've been through the illustration before. what we've been offered today is simply a correction to some minor factors that should have been done slightly differently. It doesn't change the intent of where this is headed, and we should just move forward to it.
Thank you. Yeah, I would certainly agree with that. I think the graphics are an improvement. It sounds like the neighborhood association is in favor of it, and it seems to consistently reflect the dimensional criteria of our code, so. There,
I move we accept these plans as now presented to us.
do we have a second?
I second.
All right. Any discussion? Seeing none, all those in favor, say aye.
Aye.
Aye. Opposed? All right, motion carries. Thank you.
Thank you.
This is a tentative decision by the commission, and findings be brought back to the commission the next meeting on the 24th.
All right.
Can I just compliment the staff? This has got to be the greatest staff I've ever dealt with. You guys are incredible.
Well said. All right. Moving on to number 8 on the agenda, other business. This is the monthly update on state rulemaking process for House Bills 2001. Got Eric Olson here with an update. Please go ahead.
Thank you, Acting Chair Stewart and the rest of the commissioners. So I was able to prepare a staff report where we did our best to highlight some of the more pertinent issues that are being discussed currently at the meetings that are going on at the state level regarding HB 2001. We did our best to highlight in sort of the bold text within the executive summary. So we not only added the executive summary, but tried to highlight the sort of top line points that we wanted folks to pay attention to in bold. So I suppose, what we want to do here is just open it up for comments. There are a lot of, or questions rather, and comments. There are a lot of details and questions that are still being worked out, and a lot of answers that we do not yet have. But there is a model code for medium cities to start digging into, and some draft language that's been accumulated. So a little bit more to look at as of this point, but still in the early stages.
Okay, thank you. Any comments or questions from the commission on the update that we have?
I had a couple of questions on page 3 regarding the infrastructure upgrades. And one was the language that specifies that infrastructure-based time extensions only applicable within the area where the deficiency is identified. And I sent you and Scott an email earlier. Sorry, I didn't catch it. Sorry. Oh, it's okay.
So yeah, I didn't notice that either. I'm sorry.
It's all good. But I guess my question is, does this mean that we're able to submit for a citywide extension, or do we have to break it up in terms of the city area or neighborhood to apply for these extensions? And was it, clarified on how we do that exactly?
So, I'm not sure what, when we do take a look at infrastructure, where we'll see those deficiencies. But the intent is certainly to have the applications for the extension, the time extension related to infrastructure, just apply to any areas where those deficiencies exist. So I suppose that theoretically, if we were able to identify a citywide deficiency, then perhaps if we were able to make the case, that might be something to pursue. But I think that most folks are thinking of this as isolated areas in certain residential districts that will be more acutely affected.
And then, sorry, I have a couple more questions on that same bit of information. Wondering, and maybe this is unknown, but does the city currently have records of neighborhoods with covenants that would essentially exempt middle housing from being allowable within neighborhoods? And if not, is there the potential for the city to seek that information through a consultant or a title company or something like that?
Yeah, I think that's a really important piece of information, clearly, in terms of what, covenants or restrictions might apply to various properties or different subdivisions or HOAs around the city, plan developments, PUDs, et cetera. So, that's something that we're aware of. We're beginning early stages of just some initial analysis to sort of get the ball rolling on some conversations that we might expect to occur in the coming months. And so one of those is to start looking at infrastructure a bit, start looking, start doing some of the background research on those covenants, especially in trying to determine, if there are areas where, we would not necessarily expect the bill to have an impact. But I think that will take some time. I think a lot of those covenants it's a lot of legal assistant work, I guess you could say, a lot of digging through large documents to try to identify those restrictions, I think. So that's something that we're prepared to undergo, but I'm not sure exactly, if we have everything that we need quite yet to do that research. But
Yeah, I think the reason I was asking is because just from a process of elimination, if there's certain swaths of the city that can automatically be eliminated from development beyond just the detached single family, that would be great. And then being able to focus directly on areas that would potentially have deficiencies or not could just be helpful for everyone, so.
absolutely.
I don't know if I should say anything.
Maybe I'll say something, and then Evan can step in if I miss anything, or if I step in the wrong puddle. So, the city doesn't maintain a database or an inventory of CC&Rs because they're private agreements, and the city doesn't enforce them other than where the covenants overlap with the city development restriction or condition of approval on a land, like maintenance of a stormwater facility. We want to make sure that if it's a planned development and an HOA is going to be responsible for maintaining a city-required stormwater facility, that those provisions are in at least the draft CC&Rs that we see that are eventually enacted. Now with this, we can do a survey of CC&Rs, and there's some developments that are pretty obvious targets. We're going to look at those first. Kind of the farther back we go, and the smaller the scale of the development, more labor intensive it's going to be. We could contract with a third party or use a title company to generate results, but ultimately someone has to read those and interpret them. And a property owner could say, I don't recognize or I don't agree. I have a different legal opinion on the validity of this covenant, and I believe I'm entitled to put a duplex on this lot. And that wouldn't be a fight for the city. That would be a dispute between, I think, the property owner and the HOA. So I think there is some value in kind of at a planning level to look at, like, what do we know, given all the caveats around that, that exists, so we can show a map, but then we need to be really careful on how we represent that because of, for the reasons I just described. I don't know if you'd have anything to add, Evan, but that's kind of the...
I would just emphasize, the covenants are private agreements of parties. And so it depends what's in there and what the language is. And, it could be that parties decide to revise their covenants. So from a planning perspective, from our point of view, I don't know that we can depend on covenants remaining static, relative to that. So I would say, obviously, we need to, I haven't talked to planning, but it seems to me that you need to analyze what your potential is, kind of irrespective of covenants, recognizing that there are probably some larger areas, but that might go to the infrastructure question, kind of like in the short term until it gets tested.
Right, yeah, I think there's a lot of, I think regardless of whether or not we can be confident that maybe duplexes could not be constructed in this particular area in order to comply with the bill, I think the city would be obligated to allow duplexes regardless in the underlying zoning, even if there were other restrictions that might prevent it. So, yeah.
Doesn't state law preempt private agreements? So,
They can only at least the way that House Bill 2001 has been written, would only sort of preempt those agreements if they were signed after the date that HB 2001 was adopted. So anything that was prior to last year, I believe it was, I'm not sure what the official date in the language of the bill is, but sometime around last year, anything before then would, continue to exist after the bill.
One last question. The portion of the findings where it's talking about local governments would need to extend infrastructure to accommodate middle housing in unurbanized areas, areas that do not currently have sufficient infrastructure within their jurisdictional boundary, only if single-family dwellings are already allowed in these areas. I guess I was wondering, is there any discussion that the state is having about, townships that have large swaths of single-family lots versus others, and how infrastructure could be staggered potentially? I don't know, if all of a sudden 90% of your city is required to upgrade infrastructure to accommodate middle housing versus a township that has, 50% of their residential property is single-family detached. Is there any discussion about, numbers of lots given in a city and how you're able to accommodate infrastructural changes?
There hasn't been too much discussion or comparison in that particular metric. I think one thing that has occurred to me is that, just thinking about the perspective of a planner from the city of Portland, they're actually facing a huge, that they deal with a huge diversity of density, and, there's extremely, very dense urban areas that are, have tons of improvements and lots of infrastructure, and then there's completely unimproved roads where, there's almost nothing in lots of areas of East Portland. So one thing that's occurred to me is that there's actually, jurisdictions that you might think of as the most urban that might not be dealing with the same issues, or actually tackling a lot of the same issues as we are, and that there's a good amount of single-family zoning in the state. And it's certainly the majority of residential zoning, it seems. So, yeah.
Okay. Thank you.
Lake Oswego has a lot of streets that are quite narrow. Has there been any discussion about what to do about not forcing housing or parking onto the streets in those cases? Because the way the law reads, you can't require new housing to have parking on the lot, in which case it would could force parking onto the street where there isn't room.
So I'm actually unaware that on-site or off-street parking would be, I'm not aware of any preemption of on-street parking that's in HB 2001. I know that for an accessory dwelling unit, there is something that would relate to, saying that you can't have, or you can't require that additional space for an ADU. However, for a duplex, there are a number of options presented in the staff report that I put together that they're discussing now. All of them would allow for at least one extra parking space for a duplex. They're worded differently, and each of them are sort of proposed as a cap on parking that cities could be allowed to require. And that's one thing I wanted to point out. But other than that, with respect to the on-street parking, the proposed minimum requirement would not require cities to credit on-street parking for the minimum parking requirement. So there's nothing at the state level that will really force that down our throats. However, there is something in the model code that would recommend providing credit for on-street parking where feasible, where there's sufficient space. But I haven't heard anything that would necessarily force that.
Well, the law specifically precludes the city from requiring parking on the lot.
For ADUs, that's correct.
No, in general, for middle housing.
The conversations that are taking place at the state level right now would require additional parking for the duplexes. That's the way that the rulemaking committees have been thinking about this. And again, the language, as we've interpreted it, and the DLCD has interpreted it, and the consultants would only prevent parking from being able to be required for an ADU, to our knowledge.
There seemed to be the issue of the time crunch. Do you have any sense that they will give you more time, or?
The last meeting of the infrastructure TAC, or Technical Advisory Committee, they were pointing out a lot of the difficulties in terms of that particular process, because obviously folks would want to apply for the extensions prior to when they would need to adopt a code that would comply with HB 2001. So, the deadline for that would be pretty soon for medium cities, actually. Medium cities have even tighter deadlines than we do as a large city, because there are more requirements for large cities, but we'll get into that a little bit later. But regardless, there's no talk of an extension that I am aware of. There's talk of perhaps having very loose application requirements and minimal application requirements, considering that there's not that much time for jurisdictions to put together applications for the infrastructure extension. But all I've heard so far is just a lot of people identifying that as a huge issue. So they're at least aware of that at the rulemaking committee level. But I will just point out that those deadlines are actually in the bill itself. So there's only so much that any rulemaking committee could do to modify that in their capacity as an advisory body. So.
I think if everybody's concerned, somebody would do something. But.
Or at least come up with a feasible alternative of some kind, yeah. But we'll see where it goes. They've only met, I think that was the first meeting of the infrastructure committee, so it's still early.
Comment on or I guess maybe a question on the infrastructure topic. Traditionally, when a landowner has decided to improve or upgrade their property, and they're doing something that's going to put a strain on water and sewer and things like that, it's always been on the burden. It's been the burden of the private property owner to make those improvements, pay for the cost of those improvements. Has there been discussion about, sort of, since we're talking sort of more of a global improvement, is there going to be some sort of line of demarcation that you're aware of, where is these improvements going to be expected of the private sector, or where does the public sector step in?
That's a good question. There was some discussion of that. So there was some discussion of that at the Technical Advisory Committee. They proposed, or the DLCD rather, proposed a rule of thumb for these infrastructure rules. So it's not a rule, it's more guidance for the rulemaking. But this would essentially say that cities or local jurisdictions would not be forced to provide infrastructure that a developer would typically provide in conjunction with residential development. So I don't think they've demarcated that very clearly quite yet. I think it's different depending on the jurisdiction too, so there might not be an appetite for the state to go through and make that determination for cities. So I think, there is some guidance in there. I'm not sure where it will land, but I don't think they're intending to force cities to do things that developers wouldn't do necessarily. And, I know that there have been, discussions of how do things like a local improvement district play into this? How will this, or how much leeway will cities have to modify their systems development charges to accommodate new development, et cetera? And so, these are questions that are being discussed, but unfortunately, not too many answers, and only have some sort of guidance and no clear line yet.
My other question that I have is on the duplex topic. Do you have a sense of sort of which way committee is leaning as far as how they're going to interpret what a duplex is? Because I think we all know, the traditional idea of a duplex is a building with, an attached, with basically two households in it, a common wall. And that's been the interpretation of the building codes for for years. And now we've got this idea that maybe a duplex is going to be potentially detached. I guess my comment would be if they go that way, I hope they come up with a new term for it, because it's just going to be, I think, confusing as to what that is, you know. But do you have a sense of, I know it's been introduced recently, do you have a sense of which way they may be going in that interpretation?
Yeah, you know, I note that the DLCD proposed the standard definition that we're mostly familiar with, the 2 units within one building with a shared wall or floor or ceiling. And, you know, I think there were some folks that commented that maybe they wanted more flexibility, and, you know, I will say that those folks were from the more urban areas, I guess, and more development-oriented perspectives. And, you know, I think at minimum they were kind of asking for flexibility to think about it differently in certain jurisdictions, but I would be very surprised if we didn't land on something that was, or if the committees rather didn't land on something similar to the building code definition that we're all familiar with. I think just for ease of understanding and commonality and just discussing this term,
I think that
it
would
go a
present
long
you a
way.
huge level of complexity in trying to sift through that and define setbacks and mass and FAR and all of that if they went that way.
I'm not familiar with a detached duplex, but apparently somebody wants to build one, so.
Any other comments or questions from the commission? All right. Well, thanks, Eric, and please continue to keep us informed.
Will do, and yeah, I've been spending a lot of time in Salem lately, so. If anybody has anything else they want me to be doing down there for them, just let me know. Lots of meetings going on.
All right, will do. Thank you. All right, so we are at the end already. Item 9, the schedule review. Mr. Siegel.
Yeah, thank you, Commissioner Stewart. The next meeting on February 24th, you have a public hearing on amendments to the Historic Preservation Code. These are changes that the city has been working on with the Historic Resources Advisory Board over the past year, and they're incorporating some changes at the state level and standardizing our historic preservation criteria to be more consistent with the Secretary of Interior's criteria. For example, proposing some process improvements in the way that historic preservation or historic landmark reviews are permitted in the city, and so that's on the 24th. That's the only item on your agenda, the only public hearing item on your agenda. Just as an update, work on the seasonal outdoor dining enclosure review of the code is underway, and so the staff planner on that is Evan Franstead. He's scheduled focus group meetings so that even though you're not seeing him or hearing from us on that, the staff is working on it and is scheduled to come back to you in the spring with that. So that really probably concludes the schedule update for now, unless you have any questions. Thank you.
All right, well, I think we're at the end. If there's no further comment, we can adjourn the meeting. All right, meeting adjourned. Thanks.